Afternoon on the topical subject. Friends, as you know that on 13th of this month, IBBI came out with a facilitation letter highlighting some of the mistakes, and deliberately I've written on common mistakes, highlighting some of the common mistakes according to IBBI which are being committed or have been committed by some of the IPs while assigning or while having their assignments either as IRP or RP or liquidator or authorized representative. According to IBBI, these are some of the mistakes and can be avoidable or could have been avoided by the IPs. I'm really grateful, friends, to IBBI for highlighting these mistakes, because through this particular letter, IBBI has not only highlighted the mistakes, but IBBI has actually provided some sort of advisory or clarification or guidance also, or some of the doubts have been removed through this letter. But as the letter suggests that it's a facilitation letter, I would have expected IBBI to actually facilitate the insolvency professional on these mistakes which have been highlighted in this letter. Simply by highlighting the mistakes does not serve or may not serve any purpose. Simultaneously, IBBI should have actually facilitated how these mistakes can be avoided. Because some of these mistakes, friends, may be by way of ignorance, may be by way of negligence. Some of the mistakes may be technical in nature. Some of the mistakes may be beyond the control of the insolvency professional. And some of the mistakes, despite all efforts on the part of the resolution professional or IRP or liquidator, are bound to be there. Actually, I say that to err is human. Insolvency professional is also a human being. He is also not a god. वो भी भगवान नहीं है. For him also, this law is at nascent stage. Like everybody else, if law is at nascent stage, whether it's for the regulator or for the adjudicating authority or for the bankers or for anybody else on this earth, this law is a nascent stage for insolvency professionals also. No insolvency professional was born expert in IBC. This legislation is only 3 years old, maybe 4 years old by the next month. And so this law is 4 years old for everybody, including 4 years old for insolvency professionals. According to me, no insolvency professionals should be prosecuted for these common mistakes unless there is some mens rea. Unless there is some malified intention on the part of the insolvency professional. Otherwise, I tell you, some of these mistakes are actually nothing but the practical steps, the pragmatic steps which have actually been taken by the insolvency professional during the conduct of the business of insolvency or resolution. So when these pragmatic steps, because nobody had the answer at that point of time, when these issues arose before the insolvency professional, nobody had the answer to that. So according to the situation, according to the circumstances, he might have taken certain decisions, he might have taken certain steps in the interest of the corporate debtor as well as in the interest of the stakeholders. Actually, for this purpose, if he has taken some practical steps, some pragmatic steps, there might be some technical violation of the provisions of the code. But for these steps, according to me, the insolvency professional should be assisted, but not persecuted or prosecuted for that purpose. This is my personal opinion is. Now, friends, with this brief opening remarks, I will say that wherever such mistakes have happened, I think these mistakes are nothing but condonable or pardonable also. Or in some cases, only a warning can be issued or some reprimand may be issued instead of suspension or instead of levying certain fine and all that. Now, through this letter, IBBI has actually highlighted 26 common mistakes from A to Z. And we are having approximately 120 minutes or 110 minutes now, I'll say, at our disposal to discuss all these 26 issues in this 110 minutes may be a Herculean task. So what I suggest, and I request my panelist friends also, that I would like to raise one of the issues. Actually, what I've done for the convenience of everybody, I've prepared a PPT for this. On each slide, one mistake has been written and the operative part of that mistake has been highlighted so that I need not read the entire mistake which is written in this letter. So I'll be reading the highlighted portion and then I'll ask the views of my panelist friend on that. And on each mistake, I would not prefer to, though if time permits, certainly I'll be more than happy to ask each and every panelist to revert on that. But I would like on each and every mistake, not more than two panelists may react. But if any other panelist has to react, may raise the hand and I would give him opportunity also. Some of the mistakes certainly I would like to forego because they are very common in nature and they are not actually mistakes. And otherwise, actually, they are advisories and we are not supposed to commit those mistakes at all. So I would not like to have any discussion on those mistakes. With this brief background, now I would like to share my screen. Where is this? Yeah, here it is. I hope everybody is able to see it. Yeah. Okay. Now, straightway I come to the introductory para of this particular facilitation letter. This is the introductory 3 paragraphs, and I would like to highlight the para number 3. Actually, by mistake, it's written 2 here. Is paragraph number 3. It says that IBBI and insolvency professional agencies have come across some mistakes being committed by some of the IPs in conduct of CIRPs. These mistakes are costs to the CD and the economy and often amount to contravention of the provisions of the law. I can understand in some of the cases, these may amount provisions of contravention of provisions, but writing wordings like this, these mistakes are cost to the CD and economy. I remember when IBBI came out with the discussion paper on the number of assignments to be done by the insolvency professionals. Even in that letter also, an indication was given that whatever wrong is happening in the CIRP field, that is because of the insolvency professionals. I think was each and every wrong thing which is happening in the insolvency regime, the insolvency professionals are not the only professionals who are responsible. Rather, also they are not responsible, if you ask me personally. If you have to fix the responsibility, the responsible for fixing of the responsibility, there are other stakeholders also. Many a time this delay is on the part of COC. Many a time this delay is also on the part of the adjudicating authority. You file an application and for months together, for years together, you are not going to get any order from the adjudicating authority. But sometimes adjudicating authority is also right in its part because they are overburdened. They are also not having time. If you on that particular day, you are listing 50, 60, 70 cases before the two members, they are also human beings. They have also their own limitations. And then because of the pandemic and all that, certain the working across the country, across the globe has suffered. And because of the suffering of the working, certainly adjudicating authority, despite its best, they have not been able to come up to the expectation of either stakeholders. So simply by saying that these mistakes cost to the CD and economy, I think this is very harsh from IBBI as far as we, the insolvency professions, are concerned. But anyway, I always say that boss is always right. IBBI is regulator, our boss. Whatever they say, we have to take it from them. Now I come to the first mistake which has been highlighted by IBBI in this letter. And here what they have written, the title is Assignment Without Having Authorization. And recently we have seen the number of IPs cases have gone to disciplinary committee where some sort of fine or otherwise has been levied on them because they have taken certain assignments without having any AFA. Now the question is on which date you should have AFA, whether on the date of the consent or on the date of your appointment or engagement. And if you give consent today, your AFA is valid till 31st of December and you are given appointment by NCLT in the month of February 2021. How can you be held liable for that? How can it be a mistake? I would like to invite Mr. Sanjeev Ahuja if you can give your views on this. Mr. Sanjeev Ahuja and Ms. Deepti Mehta on this.
Okay, great. So good afternoon, everyone. This, of course, gets started with me, so I would really want to kind of go slow here. The statement you've already made is something which I totally concur with, that what exactly is the date, the relevance of AFA? AFA is a kind of a CPE. Apparently, it started with some different thought. Eventually, there were too many preconditions which were added to AFA, and including the CPE. Now, if I slightly go into a different tangent, even to kind of, get the CPE credit is a Herculean task. Now, the simple point which I want to make all across is using technology, having the people, at their disposal, why kind of proper planning and a see-through mechanism is there before we put on something and eventually we have to withdraw or keep making changes. And that really becomes a nightmare for the IPs who are in any case struggling with the other compliance and timelines issue. So the point you made is date of consent or date of appointment. That is something which is very valid. We have seen the DCs. In most of the cases, it was at the time of giving in consent, the guy had no idea. The appointment happened whenever it happened, and then you can't control. I would also link the typical Section 9 applications or where people get appointed from the panel. They have no idea what time, how much time would that take. But there's another point. If we do not have the AFA and somebody says that we cannot pick up an assignment or we are not eligible, on a given day when you are appointed, is there a mechanism which has been laid out so that you can reach out to FC, OC or to NCLT and say, I tried my best because of ABC reason, genuine or not genuine, I have not been given my AFA, hence I am not eligible. Is there a mechanism somewhere there? So even if you are talking about only a one-way traffic, let's think from the perspective of the IP. I tried to get us AFA, I did not. In the interim, I get an appointment. What exactly do I do? Somebody has to think through all that. Let's try and close the loop every which way, so that whenever we pick up a particular issue, whether it's a mistake, common mistake, specific mistake, let's try and think through and give the credit or the benefit of doubt to the IP also. That is something which we feel missing. So, and the other point is having seen that because of the initial policy, which was a new policy about the AFAs, there's a lot of confusion, be it on the timelines, also about the duration, and then linking it and to be in sync with the NCLT panels. All things, I guess, over the period, dust will settle, will have clarity, IPs will have clarity, IPA will have clarity. And that is what we are seeing, they created a panel and they have to kind of withdraw that and probably split now into two parts. So from that perspective, why so many DC orders? Why there's a common mistake? Why not a mistake is started with a policy just slightly flawed? And now we're trying to understand. So that is my kind of, two cents on that. That this in any case would have settled. One simple advisory that please ensure that you have a AFA on the date of consent, and we'll try and have the appointment within some time. That should have been given the right direction to all the people rather than 7, 8, 10 lines and suddenly it seems we have committed blunders and all that, where an IP is not responsible for all that. So that's from my side.
Thank you, Mr. Sanjeev. Actually, you and me are on the committees of two of the IPAs also. I think we can request to our IPAs also, because the AFA has to be given by the IPA. We can request our IPAs also to consider it, that AFA should be considered on the date of the consent and actually not of the date of assignment, date of.
And a small repetition, though I've already mentioned that the CPRs, which is one of the basic conditions of the prerequisite, again, there has to be a mechanism. When I enter, when I put in my credentials, there's enough technology. People have been doing it for more than a year now. So they have the credentials. Now, by default, it should get accepted, it should get recorded, and my CPR should be visible somewhere. Otherwise, how am I supposed to kind of keep a collection of that? I attended a particular session there and a particular session there, and then put up all those details. I mean, this is too procedural, and this is not leading out to any productive usage of time. So I'm sure technology can take care of all that.
Yes, over to Ms. Deepti.
I think Mr. Sanjeev has covered many things, the majority points. The thing that there should be in between, since it's just started, it has implementation H. So at least they should allow IPs some leverage of that. And just like recently they have done that, they have not empaneled and many issues have raised, and then they are coming out with the corrections. So everyone is trying their best. So even IP should be given opportunity that AFA, and Mr. Sanjeev rightly mentioned that there should be record at IPA level as well. Like we all have a professional agency, like as and when we register for the program, it get recorded. It helps a lot. Again, there is a timeline to apply for that CP hour. So many times it also lapse, then you don't entitle. So there are practical issues. Looking at that, there should be leniency at the current stage. Thank you.
Okay, thank you. Now I come to the second mistake as per the letter.
Just small suggestion on this. Since you're mentioning talking to when the regulation came in, they had given time till 31st December 19.
Right.
And they permitted the existing members to continue with their assignment. So why can't you have a situation where when you applied for or you give your consent, you can at least continue till you are an IRP and decide during that time whether you want to take the registration or continue with this and take registration in that 1 month of your AFA if you're not done already. Otherwise, you cease to be an IRP before you become an RP if you don't want to continue.
Okay, second issue is fee payable to IPs. Now here the issue is what IBBI, this letter say that whatever the remuneration is being paid for the services, it has to be paid in a transparent manner. It should be reasonable. Actually, reasonable word is being used by IBBI many times when the fee is being paid to the IPs or to the professional. The fee has to be in transparent manner. It has to be reasonable. And if you look at the bottom, it says that it has been observed in a few cases that a fee payable to an IP was not fixed beforehand, and the IP drew a fee on his own without approval of such fees from the competent authority in contravention of the provisions of law. Now the question arises, who is to fix the fee? According to me, in the very first case, if the name of the IP is given in the application, then certainly it is between a contract between the applicant and the IP. At that point of time, the applicant may fix the fees, and then he shall be paid whatever is ratified by COC. Number two, suppose if his name is not there in the application, then adjudicating authority will make an appointment out of the panel, and at point of time, adjudicating authority never fixes up the remuneration.
Never.
And third, whenever there is a dispute between the IP and the COC and matter goes to adjudicating authority in number of cases remarks back the matter to IBBI that you please fix up the fee, you recommend something to us and we'll fix up the fee. Matter goes to adjudicating authority, appellate authority remarks back the matter to adjudicating authority. Actually, IP becomes a shuttlecock that who is going to fix up the fee and who is going to pay the fee. Now the letters say that he has taken a fee which has not been fixed by anybody. And number of times we see that COC does not fixes up the fee. If COC also does not fixes up the fee, adjudicator only does not fix up the fee, who will fix up the fee and who will pay the fee? To whom should he approach? I think here a facilitation should have come from IBBI, fixing up this responsibility of finalizing or fixing the fee and payment of fee both. But to that extent, this letter has remained silent. Now I request Yogesh on this. What is his view?
Rightly pointed out by GP that it's a very, very most controversial matter in the IBC, I think, during the CIRP process. I think most of us are facing problems relating to the fees. Most of us are not getting payments during the CIRP process, maybe due to the non-fixation of the fees by COC, And many times we are becoming a shuttlecock, as narrated by GP, between NCLT and NCLAT. And this is a very serious matter, but the problem is that I think there is no solution to this kind of a issue with respect to the remuneration, because fees is never decided. Even if it is decided, it is only for the with the applicant for the first month. Second month onwards, it has to be decided by the COC. And COC is looking from a different angle. They are not looking into that what an IP is supposed to do. Their benchmark is only that who is the L1. Like in EYs, when we are, submitting our expression of interest to banks, they are looking at who is the L1. Now, L1 is not the right way to look into the fee payable to the IP. It depends on the IP that how much he is experienced, how much he can take care of the EIRP process, what he can deliver, what he cannot deliver. So there are so many parameters to decide the fee part to the IP under the CIRP. So it is very, very difficult for any person to derive any formula or any methodology to decide the fee. The only thing which is required is by the IBBI is that there should be a responsibility to be fixed on the COC to fix the remuneration as early as possible, might be in the first COC itself that they should decide the fee. Or otherwise, if the IP is not agreeing to the fee proposed by the COC in the first meeting, then he is free to choose the IP to continue as an IP in that CIRP, or otherwise the COC can appoint somebody else. But this issue need to be decided in the first COC meeting, and it should be recorded somewhere in the regulations that this matter should be fixed up in the first COC meeting.
Now I go to my dear friend Ravi from Ahmedabad. Ravi, what happens in NCLT Ahmedabad when a matter is somebody approaches or any IP approaches NCLT bench Ahmedabad for this purpose of fixing of the fee? So what is the attitude of the bench there? What is your experience?
So of late, they are taking positive attitude and directing, especially in respect of IRP, they are directing the applicant who had made the application. Surprising, Madan, in my last order, which I received few days back, they have even directed the financial creditor to pay an X amount before along with the order. In the order also, they have given direction. Then X amount has to be paid to IRP before the proceedings are started, and that's a compliance to be done by financial creditor before the process begins.
But that's very common here in Delhi also. That is not IRP's fees. That is towards IRP expenses.
And this one more thing is there that
this has been recently started by Ahmedabad now. It was not there earlier.
Delhi it started years ago.
Not only this, they are not giving this order of payment of 1 lakh or 2 lakhs towards the cost. Actually, costs include the IRP fee as well. But the point, in many cases, even after the order has been issued to pay up 2 lakh rupees by the applicant to the IP, the payment is not being made, and in many cases, the IP is to go to NCLT again to make and give an order for making payment of this rupees 2 lakh. This is very, very, difficult circumstances to the IP to deal with such situations.
I'll give an extreme example, GP. In one of the case my colleague is involved in, a banker wanted to withdraw has moved an application to withdraw his claim because realizing that there is no assets available in the company and he would be required to incur expenses. So he has moved an application that he wants to withdraw his claim so that he doesn't require to bear the expenses.
In one of the hearing today itself, the judge is asking the IP that what you have done. What is the answer to that question? That becomes very, very difficult question for the IP, that what you have done. Now, if he says that he has written the letters, he's following up this and that. So he's asked, if the judge is asking that for this, you are asking for 1.5 lakh rupees or 2 lakh rupees or 1 lakh rupees, which is not reasonable. So it is a very, very different kind of a situation for any IP to look into that.
Okay, now I come to
Madan, one practical thing I will tell in my case, that actually in my case, my lawyer was present. The matter of Section 19 is going on. And he just admitted, I am not paid the fees. And the judge was so upset because he has seen my work. He said that you have done work so much. And he took FC left, right, and he says, in 2 days you pay the fees. And he fixed the date. He said, RPS, and then he himself created. I said, sumoto I am creating and giving the order. They did not pay it in 2 days. In next hearing, after 1 week, they asked, not paid, equal amount of penalty they put on the FC. If you will not pay, double. So it's an exceptional thing. I have not applied, just on my oral submission they have done.
Now coming to this word, fee has to be reasonable. Sometimes I see that IP should take into consideration the future litigation also, which he may have to contest and fight. Some of the number of cases may be filed against the resolution professional or insolvency professional also. So whether should cost of litigation be also considered while fixing up the fee, and whether including that fee will be reasonable or not? I would like to have the views of Sanjeev Ahuja on this.
Okay, so thank you. Before I kind of, answer you directly on the query, 2 points which you made earlier in this regard. One is, till date, the word, the nomenclature which is used, reasonable, wherever somebody feels like using it, I have not figured out what exactly, how do we start to understand, or what kind of a parameters or benchmarking we require for reasonableness. That's one concern, because that becomes a good word to be said at open forums and to be used in letters and wherever, but nobody is belling the cat by defining what exactly is reasonable. Point one. Second thing is, forget about, we already had a lot of discussion about whether it's reasonable, not reasonable, coming from applicant or COC. Most important, the last bit, who assures us that at the end we'll actually get paid for the efforts. Now, you just said, somebody might, a bench might ask what exactly you've done, what not done. When we are supposed to ask what we are supposed to do, somebody comes back and tells us on our face, didn't you read section 17, 18, 19, 20, all that you're supposed to do, right? Similarly, we pass an order, the order actually says you're supposed to do all that. So these questions ideally should not get started. There should be a concept of some minimum fees, some grading or something, but the word assurance coming from our side as a counter to the reasonable. So somebody keeps saying reasonable, we need to keep saying assure us. We'll be reasonable, but assure us. Now, direct answer to your question, unless until, we have the, the control, or there is a lack, this continues, the lack of trust deficit, I would say, trust deficit continues between the CD and the RP, or it continues between the COC and the, and the RP. If you're not on my panel, I won't allow you this much fees, I'll probably check you out. When all those things will keep continuing, we'll have a problem. And in a space, in an age of L1, you are wanting to add the contingent liabilities, right? Today, somebody is even wanting to understand what exactly you would be doing, whether there are assets, no assets, those are the parameters. When I open a UI for 300, 500 IPs, they keep fighting, there's a lot of undercutting, and they are like, just in the, for the sake of stepping in, getting an assignment, they are willing to quote as low as like, a shameful numbers, frankly, whatever be the reason. On top of it, in the same breath, how can we even expect that you want to keep further buffering or some kind of a layering where you'll say, eventually there'll be litigation and hence I need to be covered for that. So let that be a query to IBBI, to the regulator, to the adjudicating authority, that if and when there is a final order, which is either a resolution plan getting approved or a liquidation getting announced, whatever it is, that was supposed to be a discharge order for the RP, right? I think it's very clearly written everywhere. Is that discharge really happening? If somebody tomorrow goes to at the next level at NCLAT, and I get a notice, I become a respondent and all that, what exactly I'm supposed to do? I thought I'm discharged. The order was supposed to be final for everyone. So believing in that, I never thought that I need to have a contingency plan. But now what we keep hearing and what we keep seeing on the ground, yes, that's required. But then again, a counter in a space, in an age of L1s, how can you actually increase the amounts when you're fighting it out for those peanuts to kind of handle a corporate data? That's my take.
In the meantime, in chat box, we have received number of suggestions and comments from the participant that fee should be fixed. Fee should be fixed by somebody, whether the applicant fixes it or COC should fix it up, or IBBI fix it up, or NCLT fix it up. But it should be fixed. It should be paid. There should be total clarity on this fees. And the word reasonable, number of participants have written that word reasonable is very, very subjective. Clarity on this also. Okay, now I come to the third.
Madan, one point. In one of my suggestions, I'm telling that there should be 12% interest for late payment of all the insolvency cost and liquidation cost. If they can earn, they have to pay for this also. That is the suggestion.
Who shall pay this cost? 12% interest?
See, if corporate debtor has fund, we can recover. The situation comes when FC has to contribute.
May I request you to write to IBBI also?
I already given suggestion.
Okay, great. Excellent.
That is indirectly covered when you are raising an interim finance to meet this UC cost. And
exactly.
It is some interest.
This is my cost also.
If it is not raised, then the interest should be provided.
So let them not pay. I will earn interest. It leverage. No, I also incur the cost. I deserve that. And others also. All consultant. We don't pay to consultant.
Interim finance is part of the CRP cost and it gets the super priority. Similarly, the RP's fees is also part of the CRP cost, be it liquidator or IRP, RP. So from that perspective, you have a point that it adds a pressure to the payer, right? So whosoever it might be, irrespective of the CD has money or not, at the day and finally, even in liquidation, it has to adhere to a waterfall. And since CRP gets a top priority, so let the RP's dues also come, but with an additional cost. So I think that's the point, but I'm sure people will expect we are not being reasonable here, so we'll have to justify that.
I think we are not doing justice with ourselves as well as with the participant, because this is such a subject where we can spend entire 2 hours.
Yeah, we can spend the entire 2 hours. Absolutely right.
In fact, in one of the hearings, the judges were asking the IP that for how much period you have got. He said only for 2 months. Then why are you working for the other balance period when you are not getting your fees? What is the answer, to all these questions?
Okay, now coming to this next issue, application for cooperation. Here the highlighted portion says that IRP, RP must act with promptitude and file the application wherever required without any procrastination. And it says, actually they are talking about filing of application under section 19(2) for non-cooperation and all that.
Yeah.
Then it says, any delay in filing application despite containing non-cooperation may reflect undue influence of the promoters on the IP and endanger the life of the CD. This is two biggest statements from IBBI.
Absolutely.
That if you do not file this application, now one question is arising which comes to my mind is, if this IRP or RP is not getting his fees even, he is not getting any CRP expenses. Now you expect him to file this application also. He has to engage a lawyer. He has to attend the dates. And in how many cases these applications have actually been decided and disposed of? In how many cases the adjudicating authority has come to the rescue of the insolvency professional and the directions have been issued? And despite those directions, the promoters have come forward and they actually cooperated with the insolvency professional. I would like to experience a couple of you, not all you four, because this, I know this is everybody would like to speak on this. I think you decide yourself who would like to speak on this.
Only one point which I would like to make is that, as you have already rightly pointed out, that all of us have been filing this application under section 92 against the promoters for non-cooperation. But finally, what is the result on such applications? All these applications are pending for months together. And despite in directions in some of the cases, the information is not coming. So any deterrent action has not been taken against the promoters by any NCLT so far. So that is actually the lacuna that the people are facing, because this section 92 is becoming infructuous because of any concrete orders in this respect against the promoters.
But Yogesh, let me tell you, if you file the application, you may or may not get the order. But if you do not file the application, you will receive a show cause notice and you will be held guilty by the disciplinary committee.
So that's a basic problem, GP, that you have no other option but to go ahead and file the application, whether NCLT passes an order or not. One of the case, NCLT passed an order that if you're not getting assistant promoters, go to the police station. And now you go to the police station and deal with them. You know how they behave, and end result is again you're back to square one with NCLTs or no cooperation from anybody. Now you decide what is to be done, and that application remains pending for years together.
So what you are saying is basically a formality of filing the application without any concrete results on this.
Deepti, have you filed any application under 19.2?
In 19 each case.
In
And an
19
order is given, no one is supporting. Also, I'll tell that even they are telling any delay, very subjective. I will not file the case, means you decide the period, what is any delay, when the delay will happen. It's very subjective. If I go, again, if you go to NCLT without effort, they will say, Arey, what you have done? You are coming like that. And that filing and listing our application take time. So in meantime, I have to try. I cannot go on first day and start complaining. So what is the criteria of delay? When I should? That is a very subjective matter. That if I am trying to get the information, I tried my best, I've gone to registered office, I gone to MCA, I gone to income tax, I gone to chartered accountant. I will take effort first and then I will file. Any delay. So what is delay period you are talking? Second point, here also I have given the suggestion to IBBI that there is a list of information which we know we need it. The case should not be admitted. The order is decided, it is admitted. Order should not be issued till the promoter deposit this information. Otherwise, this case will not move for 3, 4, 5, 6 months. So you don't issue the order and appoint insolvency professional. So the process only doesn't start. Otherwise, it will. Otherwise, section 19 application will be always there.
Deepti, in the beginning, how can I have NCLT be sure whether promoters are going to cooperate or not before admission? How can they?
I am not telling that they will not cooperate. We don't want to decide that, and that's why we need information in advance.
But in that case, promoter is more than happy to not to share the information. He knows that unless he shares it, he will not get admitted.
Exactly. Now here you come. So we get appointed and we have to deal. So give the information. We are ready to work. It's a minimum information. We know what is required.
Actually, Sanjeev is simultaneously preparing for his 28th event also. He's getting a lot of talking points for that day. Sanjeev, what is your view on this? Very brief.
So, I mean, all of you have already covered. I'm just kind of summarizing it. We need to understand what is the definition of delay and what is the definition of non-cooperation. This is the RP who's on the ground, who's dealing with the people, the CD, the promoters, the employees. For them, we are officer of the court, it's okay. But we are a new animal for them. They have no idea we're a stranger, it takes time, right?
Absolutely.
In my the cases, I have avoided getting into 19.2. It's not that I was given a red carpet welcome. It is not that like I was given whatever I wanted. We had problems, they created hurdles, all that is fine. But the way the language is used, this actually is like, promoting litigation, let me tell you. And you get on against the promoters by reading this, that, because any delay and somebody will come after you. So what will happen is a lot of people who are watching now, by default, for them, it will be SOP. You get an assignment in the very 10, 15, 20 days or a month. Let's prepare a 92 by default because we need to do it. You go to NCLT, the so-called non-cooperation will turn into hostility. Now, that is not the way, this entire restructuring and resolution is going to happen. You are actually pitching us against the cooperator and the team. So, to me, somebody should have got deeper into it. Why exactly somebody is not cooperating with you? Is it like in a case of a clear malafide intent, needs to be treated differently? But this statement is like, is applicable all across. So these are wrong signals. I mean, I personally, I'm not, you understand, like, my approach is more of a mediator kind of a thing. So, as an IP, I would never want to kind of, go with a mindset that this guy will definitely come after me and all. I need to make him comfortable. We need to try and address the queries. Yes, some differences will probably get addressed. Not all of them, but yes, this has to be left to the judgment of the RP. Let us not be doing a spoon feeding here. We're all with 20, 30 years of experience. But the statements written are like, like a 48, 20th day, file a 19.2. Let me tell you the way things are. In the next timetable, you will have like, within 30 days, you have to file a 19.2. I don't care whether they're giving or not. So, I mean, that doesn't work. We have to kind of, have a different perspective. So that's my take. Like, I continue to hold that. And
okay. Now, in the meantime, Yogesh, we are very short of time. We can't devote so much time on one particular issue. Now, let me read some of the comments or suggestions of the participants also, please, on this.
Just
one of Mr. Juki has written, Yogesh, just a minute. It is very difficult to get the order from adjudicating authority on 19.2, but being IP, you are scapegoat for not filing the application. We have bad experience in filing under section 19.2. Another. Number of orders, but management did not follow any order. CIRP is about to complete. Application is still pending. Next. Adjudicating authority is playing a defensive role on application under section 19, which defeats very purpose of it. Absolutely. Next is, if the circle of businessmen and promoters, IBC and NCLT is taken as a failed system. Okay, this is a general comment. Next is the view taken by Ajinkya K. The view taken by NCLT Mumbai is that the RP's file application, section 19 application as a matter of process without taking sufficient efforts, which in my experience as a council is not the case, but that's the kind of taken by NCLT Mumbai. Another one is COC guidelines must be issued. COC is not accountable for any issue. This is a general suggestion. Sanjeev's voice is very low and not clear. Okay, message for Sanjeev. In some cases, adjudicating authority said that 19.1 already provides the directors should cooperate. Even adjudicating authority can only order the directors to cooperate, which is repetition of the same provision. And there are, in some cases, adjudicating authority said 19.1 already, okay. There have been suggestions that IRP shall file 19.2 within 21 days, even before forming of COC. Oh my God.
Don't you think I got the whiff of it? I already said that.
Okay. Adjudicating authority, IBBI and IPA want to blame IPs for their own failure on many issues and loophole of IBC 2016. No comments for the time being. Okay, now I come to the Yogesh. You have to excuse me, because number of issues are to be discussed.
I just want to add one thing, that while passing the order for initiation of CIRP, they are making so many paras for the orders. One para can be specifically dedicated to section 19, wherein all the directors and other participants should be ordered to provide the information as required under section 19.1.
Yogesh, I'm sorry to say, I've seen such direction in principal bench number of orders, admission orders. I've seen such directions, and it has also been written there that if the promoters, directors, or management or auditors do not cooperate, the IRP is at liberty to file section 19.2 application. That I've seen a number of orders.
That would be better, because it will avoid a lot of section 19.2 applications.
But I agree with you. It should be in all the orders of all the admission orders of all the NCLT benches across the country.
Yes.
Now coming to next, public announcement. Here the observation is that instances where IRP did not make public announcement promptly on his appointment, or made it later, or made it in one newspaper, or made it in one English newspaper having circulation at the location of the CD. I think we need not give any comment on this. This is okay. The public announcement has to be there. Law is very clear where the public announcement has to be there. Only some confusion may be there that what is the principal place of business of this particular corporate debtor. So wherever there is a confusion, you include that place, whether that the principal place or not, and prefer to choose all India editions of the newspaper. I think that is the only remedy lies according to me.
The remedy is there, but the cost is always a question. Let's go ahead.
Cost is a question from day one.
Yeah, that's true.
Cost is a question from day one. Okay.
Again, 3 days from when is a question which is coming up. Let's go ahead.
Next is updating of list of claims. The observation is that there are instances where some IRP or RPs did not display the list of creditors on the website of the CD, and in some cases did not update it. I think the updation is required. It has to be hosted on the website of the CD, and where the website is not there, I always give advice to my clients or my friends IPs that please create a website. If website is not there, create a website and host every information regarding this claims and updation of claims on the website of the CD at least, and host it on the IBBI website also. The question is that you need to update it. Now there are confusion whether the updated list should be filed with the adjudicating authority and IBBI also or not. Maybe Deepti or Ravi, you may highlight or give your views on this.
So there is a specific direction. Effectively, as you said, you advise your client regarding updation on create a website. I think there is a specific direction from the IBBI in this regard. There's a mail stating that if the corporate doesn't have a website, you create a website. Okay. Obviously, the cost being apart, this always remain a question mark on when to and how to create and display the list of creditors. As far as the initial creditor list, there is a specific guidelines and specific directions when to do and how to do. But there is obviously no clarity. Obviously, there is no clarity on updation. Now, with this amendment coming in 90 days, you have to submit the claim. But again, NCLT has taken a view that those are again of directive nature. So effectively, you are expecting claims to come in till the last date of the resolution plan being considered.
I tell you, Ravi, one of the what has happened last week, resolution plan has been approved by COC. Now somebody is filing the claim. COC refused, RP refused. He filed an application before adjudicating authority. Adjudicating authority had directed COC or RP to consider the claim as per the provisions of the law. And if acceptable, accept it and make it replaces before COC.
I'm absolutely facing the same case where I was an RP. Plan has been already approved. COC, it is under consideration of NCLT, and the applicant has filed an application day before yesterday on Friday, stating that my claim has not been accepted because there is a delay on my part. No, he wants claim to be considered. So that problem is obviously there. Yeah,
okay,
Deepti, go ahead.
You want to say something on this?
No, so the counter is how can, at the fag end of the process when the plan has been approved, I mean, under what provision, when they are saying, like, as per the provisions of law, please try and accept it, include it, which provision says that? Initially, it was
I tell you, in such cases, the application is filed under section 60, subsection 5, clause C, as well as read with rule 11. That's all.
11. That's all.
No, but
all applicants come under that only.
No, my point is information memorandum has been prepared, given to the applicant. Applicant has put up a plan. Now COC is approved it. What exactly are we trying to do? 60 subsection 5 is being misused. So if nobody has any idea about what to do, so he goes to 60 subsection 5. I think we have to put a stop to these kind of practices.
Then the answer is to meet the ends of justice.
You see, one point is that the law says that the claim should be accepted within a period of 90 days.
Yeah.
There is no law which says that a claim should be accepted after 90 days. It's only a practice, and in some judgments, the courts have said that by going by the judgments decided by them so far, on that basis, the IP should keep on accepting the claims up to the date of the resolution plan. Then why to have provision under the code?
I tell you, Yogesh, where the claims have not been accepted after 90 days, even the IPs have been reprimanded that why you are not accepted, even though it has been filed on 130th day, 140th day. They have been reprimanded by the adjudicating authority that once we have given direction in a number of cases, you are bound to follow those cases. That's the jurisprudence which has already developed.
So why there is a
law? No, they are not gone ahead and made a change in the law. So nobody expects me to kind of, every time see a particular case, because the facts might be different. There might be reasons for the delay. So I think this would be really stretching it too far, that because we passed an order in a particular case and hence we directed. So rest all the people. So essentially, what we are saying, every new order passed by the bench actually rewrites the law. And if that is the case, we are in very dangerous territory. Then we don't need the books. We always need the latest order, and that will continue till the time the next order is not there. So I think
all of us are experienced professionals here sitting today. we need to provide some guidance also to our fellow participants who are joining this program. Some sort of guidance also we need to. They deserve.
So, Madan, my suggestion would be, even if it is beyond 90 days, let them accept it and don't burden the NCLT by going again and again.
Yes, yes, absolutely. I'm with you. I'm with you, Ravi.
Which means the person who has a claim, let him reach the, let him approach the NCLT if at all. You from your own side, you should not, because law is clear about 90 days. That's the point.
I agree with Sanjeev. I agree with Sanjeev. Law is clear.
But Sanjeev, if you don't accept the claim,
Yeah.
and that approach adjudicating authority in number of cases has reprimanded the RP that why you have not accepted the claim. That's the issue.
Sir, we'll have to live with it. But just because somebody is not following the law and we are expected to follow law, and then what happens, like, in a particular order, as what I say, you are not following the orders. We have to follow the law. Law is very clear. Otherwise, what stops the government? Let the government make the change.
Then you need to follow the Supreme Court's order in number of cases that these regulations are directory in nature.
No, for a practitioner, let's be clear. And there are 200 participants today. Let's be clear. For a practitioner, are we saying regulation is a subordinate legislation, hence law of land, or not? Otherwise, let's wait for Supreme Court to run through the entire regulations and actually decide what is good, what is wrong. So that is probably
decide whom we should refer. Because I also agree, I will write to that claimant that as per this is the provision, I have to accept till date. However, I am not entitled. So you go to NCLT, I request, I will consider strongly. I have no intention, but I cannot take as per the provisions of the law. This is a legal position. I am not intending or having anything. I'm giving the reason why I'm doing it. Now,
what I gather from here is that we need to approach IBBI that acceptance of claim after the mandatory period as per the regulations is over. Any claim which has been submitted and accepted after that is not a mistake. Or you please let IBBI approach the adjudicating authority. It should not be, you should not reprimand the insolvency professional. There has to be some clarity on this.
Sir, a small counter. A small counter here. You allow one person, and then you are depriving so many people who read the law and who didn't come to you on 91st day. Are you not going to be unreasonable for them? What will happen? And you're saying IBBI won't come after you. Those guys will actually write to IBBI stating that he actually picked and choose. Otherwise, you should have increased the option in the public announcement itself that whenever you feel like, please give us the claims and they'll be accepted. Otherwise, doing it for one person who's coming after you means you are ignoring the other people who valued and respected the law. That's the counter.
There has to be practical. Also, suppose that particular creditor could not come to know about this commencement of CIRB about this particular corporate debtor. And he comes to about this on 100th day, and he comes forward and files the claim. You say, no, you are not entitled. You cannot file the claim. That is also really unreasonable. Then I think on the other hand, then IP should be directed the moment they take up the assignment as IRP or RP, they should approach all the creditors that as per the books of accounts of the company, your creditor CIRP has started. Now you need to file the claim along with the evidence and proofs. That also.
We have done that Inspector FC, but still they don't respond.
Public announcement ki relevance kya reh gayi phir? If you have to reach out to all the creditors, then what's the relevance of public announcement?
No, you tell me. Do we
Let's take the next point.
On an everyday basis? No. Answer is not that we don't read all the newspaper on all the basis, everyday basis.
So the point is, either we get into practical aspects or we agree that the law needs to be followed. Because we are getting into natural justice, and that is dangerous as far as a practitioner is concerned. Because
I think as a practitioner, we need to be practical. That's my approach.
In that case, allow resolution applicant also after that. I have not read the newspaper. Allow that also. Why there you are taking? Be lenient there also. Let the process go on.
Okay, great. I agree. The whole objective is resolution. I agree with you. Within the timeline, so थोड़ी extension भी लगती है तो कोई बात नहीं लगा लो. I think that's not.
Per month हम charge करते हैं.
करो ना.
देता कोई नहीं है लेकिन.
Coming to next issue.
12% interest होगा तो ठीक है.
Okay. Next issue is authority of COC. Here it has been observed that no creditor, whether secured or unsecured, irrespective of its voting power or share, or no pool of creditors such as joint lenders quorum is a substitute of the COC. It has been observed in few cases that an IP took directions of a creditor having significant voting power or a pool of creditors. So what this advisory is saying, you should not take directions from the majority of the lenders or from a major lender or prominent lender. The decision of COC has to be there, and decision of COC is supreme. So you should always take direction from the COC and not from a particular lender or consortium of lender, because in the COC right now we see that some of the participants are saying, okay, we'll discuss in our JLF or JLM. According to me, no JLF exists, no JLM exists. Whatever decision has to be taken at COC, and COC's decision is final. And that is what the guidance from IBBI through this particular letter. I think, do we need any discussion on that? I don't think we need any discussion on this.
I want to just make one point that although the IBBI has given the directions that whosoever is coming to attend the COC meeting should have the power to decide. But I think most of the cases, none of the persons coming from the banking side is having a power, and they always say in the meeting that they will reach their respective authorities to take a decision on that particular decision. So this is what actually is delaying the whole CIRP process.
Yogesh, you are too conservative saying most, it is almost 95 to 98% cases this happens. Only hardly 1 or 2% cases where you get really approval in the COC itself.
Right.
Yogesh, yeah, last week, what has happened in one of the cases in a stakeholders consultation committee, the decision was taken at the SCC, but one of the major lenders in the evening sends another mail, okay, now my senior has decided something else. What should I do? Should I follow this major lender, or should I follow the decision of recommendation of the SCC? I told
SCC
him
only. SCC.
Go SCC. Now, whatever has been written to you, respond it back. That whatever has been discussed at SCC, that is final. Your boss may not agree with this, but that's the thing of the past. Now, I'm not going to agree to this mail. SCC had decided and bound by SCC recommendation, that's all. Next issue is appointment of professionals. I think we are going to take, we may take a lot of time on this, but because time constraints are there, I just read the highlighted portion here. An IP is therefore required to satisfy himself that there is a need for services of a professional, number one. Such services are not available within the CD, number two. The person is qualified to render professional service. The professional to be appointed is suitable for the purpose. The professional is not a relative or related party of the IP. And the fee to be paid to the professional is reasonable. Now an IP is advised to ensure all this. And then the observation is that there are instances where the RP appointed a professional who is the choice of a stakeholder or a person who is not a professional for professional services. So different issues have been combined in one. Number one, अगर आपको COC में कोई banker बोलता है मेरा ये value और रख लो, don't go by that. You apply your own mind. Place a list before the COC. Let COC take a final call, or you take a final call. Secondly, they are saying that person should be a professional, should be capable of providing professional services. The fee has to be reasonable, and he should not be a related party or relative. But what they are writing here, relative or related party of the IP. Here they are not saying related party or relative of CD or COC members. What they are writing is IP only. They are not writing other stakeholders here. So what are your views on this? But we should be very, very brief and very quick.
Madan, one point only. You have not read etc. Very important.
Okay. Okay, etc. is there after reasonable. Okay. Yes.
So again, what is reasonable? What is the reasonable?
Okay.
And as it is provided in the act that you can appoint, but again, all of us are struggling to get the appointment of these outsourced professionals, outside professionals to take care of many other things which is required under the CIRP. Everybody is struggling to get the permission from the COC. And if the COC is not permitting, you cannot go ahead. So there is always a dilemma in appointing somebody without the approval of COC, because the COC wants, or the code wants, that you need to appoint a valuer by so-and-so time. You need to do the transaction audit by so-and-so time. There are so many timelines to appoint all these professionals. But if you don't get the permission from the COC for their remuneration, how will the action start? That is a major problem.
I think this is a common issue, and IBBI sees of this issue. IBBI should have come out with a solution to this, because you are given the authority to IP to appoint professionals. But when it comes to payment of remuneration, that authority lies with ICOC. So what sort of authority is this to appoint? Authority to appoint only, but not to make any payment. The payment shall be approved by COC only. So where then the authority is without any authority, I think.
In
Yes,
fact,
Ravi,
out of the blue, there was a thought which came out when this circular came out, that this is a common mistakes committed by the IPs. This is what you say, consultation paper, or what is it? I don't know. Now, why don't they come out with a paper for the COCs, for the NCLTs, for the other stakeholders?
okay.
I have
So, Ravi,
given
what-
this suggestion also.
One of the seminar when IBB official was speaking, he went into an extent say if you're appointing the same person in 2 or 3 assignment, he will be considered to deemed to be related to you.
True.
Now,
Small point.
if a particular insolvency professional is comfortable with me, where he is appointed, if he takes my services and that very CD, how can he be treated as a relative or related party?
So that was the observation made by an IBB official. That's why I'm pointing it out. That's the problem is.
I would agree. And a small point I want to make here. After your yellow highlighted portion, the next sentence gets started very nicely. It says, he needs to apply his mind. I'm supposed to apply his mind, but my mind is controlled or being controlled or wanting to be controlled by somebody else. So nothing is going to happen. Number one, if I have cleared my exam, if I am otherwise capable, please have the trust. All we need is transparency and recording it. Because I take another step. What if somebody is my relative, but he's a professional? What exactly is the problem? At the end, I'm responsible for the entire CRP, right? By having a professional who's a relative. What exactly is the problem? You rightly said that they've not covered the CD's relations or the COC's relation. Even if when you want a disclosure from me, right? We are all supposed to disclose who I have hired, whether there's a category A, B, C, D. I remember in one of the forms, how much I'm paying, and that's it. So I'll be transparent. I'll disclose it to people. I'll get that minutized. Entire payment is getting ratified. Where is the problem? So having a relation with someone who's a professional is going to be a deterrent. I mean, why? So that's what I'm saying. Applying his mind and then trying to strangulate. So tomorrow they'll actually want to handhold you and say, take now the left step and the right step and now stop. It's going to be tough. So it's a wrong territory.
And
We need
also, what is professional?
I just give you an example, Deepthi, of your example only. Suppose if there is any work in NCLAT Delhi or any of the NCLT firms in Delhi, Deepthi always takes my services. Now, say if Deepthi has taken my service in 2 cases, so whether in 3rd company cases, she cannot come back to me, but I will be treated as a relative or related party. I mean, this is really too much. If she is satisfied with my services and with my fee level, then why can't he approach me in all the cases?
Very interesting thing. IBBI has started developing relations and connecting relations with humans who are not related at all. They are creating relations.
But the point raised by
who is professional?
But
Can you tell what is the professional?
But
अच्छा, एक बड़ा इंटरेस्टिंग क्वेश्चन आया रवि योगेश, एक इंटरेस्टिंग क्वेश्चन आया that can RP hire the services of professionals from IPE in which RP is a director?
But this question I don't understand. You are part of the IP entity for the very purpose. What was the reason of creating IP entity otherwise? Where's the conflict?
It means you can take the services.
No, but it's a wrong question. I actually go and make it a statement. It's a wrong question. You are part of IP entity.
IP only.
In the first place, why you became the part of the entity? Because you wanted to use the services.
And IP is allowed. to provide the services.
Answer is he can take the services from IPE. Is
Yes.
that the answer?
Yes, yes.
No, so the question was if you are part of that entity. Now they have actually utilized it further. Even if you're not part of an entity, you can. It has not done.
But point comes out of this. I think the GP is trying to say is that if IPE, where you are the director, and where IPE not passed by the COC as part of the process, whether it will not be considered as a related party or not.
What has COC's approval to do with your relationship? I don't understand. COC has to approve what expenses?
In any CIRP, in your first COC meeting, when you are appointing the RP, you are fixing his remuneration as well as appointing an IPE, and there is a certain ratio which is decided in the COC meeting.
Agreed.
So this approval of IPE is also there along with the RP.
Agreed. Absolutely.
Agreed.
So in that case, since IPE and RP is related with each other with their association, whether it amounts to relative or not.
No. I do not see any confusion.
IPE is not part of the CIRP process.
No. Why not? You are the very fact that you actually mentioned your fees and got a split and eventually got an approval from the COC is as good as saying that instead of an individual, I am appointing an IP entity who has the wherewithal. Whether I'm a director in that or I'm not, in today's context, after the changes made, you actually, even if you're not a director, not on the board of an entity, you still can go and take the services. So if that be the case, or even if you're a part of it, there absolutely is no conflict. Basic thing being you are transparent, you're disclosing that, you got a COC to know about it, and it got monetized and recorded. You are absolutely okay. Otherwise, we are challenging the concept of IP entity, which of course, I mean, again, a debate of a different day, but that's another query we have. IP entities still now don't have a mention in the code.
Sanjay, I'm of the view, I would like to summarize it, that wherever the professions are required, IPs must appoint, or they can appoint those professionals. However, wherever the professionals are appointed, it must be ensured they are not related parties. Related parties as per law, whenever you appoint, make a adequate disclosure and timely disclosure and move forward.
Sure. Absolutely.
Only question is that who will pay the remuneration of the professional? That moot question is yet to be answered, and that I think IBBI should come out with that also, and COC should be directed or mandated to facilitate resolution professional in releasing or sanctioning those payments.
But fees,
according to me, it should not be left at the wisdom of COC also, because in a number of cases, COC just never approves any fee to be paid to the professionals. That should not be there.
Right. Yeah, but that's a separate issue about the payment, which we have already covered.
Yes.
So absolutely.
Right.
That amount is valid.
Now, next is appointment of registered valuers. Here, the observation is that there have been instances where RP appointed persons other than registered valuers for conduct of valuation, and in some cases appointed only one registered valuer instead of two. I think this is okay. We don't need any debate on this particular observation.
Only thing is the modified intent is a slightly harsh word.
One of the main problem which the
Go ahead, GP, next point. Yeah, please.
Next point, I think.
But here, in one of the cases, what has actually happened, and that is a part of the disability committee cases also, COC wanted a third valuation to be done. And COC directed RP to conduct the third valuation. He got it done. And IBBI issued a show cause notice that there is no provision of third valuation. You have got this done, and this is a cost to CD. Even though COC has said it, you should not have gone ahead and got this third valuation conducted. I think that is also again too harsh on the part of IBBI. Yes. Next is payment for professional services. Again, they are saying that these services, payment should be reasonable, fee commensurate to the services. And actually here they are covering IP as well as the professionals. And the second observation is there have been instances where fee was paid to a person other than an IP or the professional concerned. it means the payment has been received in a third party's account, and this is absolutely unfair. This is not permissible. This is not allowed and should not be done. Here I am 100% absolutely with IBBI.
Absolutely.
Go ahead.
Yeah.
Disclosure of fee and relationship. I think it's again the same thing, but let me read the highlighted portion. That IRP-RP is to make relationship and cost disclosures in the manner required by IBBI. Failure to disclose these details creates a suspicion in the mind of stakeholders. This is an important word. Failure to disclose the details creates a suspicion in the mind of stakeholders about impartiality and objectivity of the IP and possibly conflict of interest he may have. I think this is too harsh. How can it create this doubt and the suspicion in the mind of stakeholders? Because this disclosure is being made with IBBI. And whether a stakeholder is having access to that, whether disclosure has been made or not, I don't know. Whether I have not made any such disclosure. You might be making such disclosure. Whether this disclosure is accessible to outsiders also.
No.
No.
Then how can a stakeholder may have some suspicion? Only regulator can have suspicion that if a disclosure has not been made, there may be some conflict of interest and all that.
I think it will be.
In some cases, some of the disclosure have been made 5 days or 7 days or 10 days delayed. Even there also the show cause notices have been issued to IPs. I think such technical mistakes could be waived or pardoned. Some condonation, provision of condonation has to be there. Okay, next is fee for.
One
Yes.
more point can be done is that ideally IPs should make disclosures in the COC meetings also, so that this kind of allegation cannot be raised.
Okay.
Just a suggestion.
Next is fee for authorized representatives. Here the observation is that ARs in few CIRPs were paid an amount different from what is permissible under the regulations. And it has also been observed that an AR engaged others, whether professionals or not, and such other persons attended the meetings of COC with the AR. Yogesh, you are there in a lot of builders cases. Actually, this belongs to real estate observation with respect to real estate cases only. So what is your view on this?
See, as far as the fee is concerned, as per the code, it is a fixed amount which is to be given to the AR. But again, IBBI should look into the role of the AR which is given to him, and being appointed officer of the committee of creditors on behalf of the allottees or on their behalf, he is required to interact he needs to have a meeting with them or have to reply to their mails, because their expectation is from the AR to reply to them. So in order to have such kind of a relationship with the allottees, because since you are a AR of all these people, then you cannot say that all these replies will be done by the RP. So I think there needs to be some changes, amendments in the IBBI regulations, where you should be allowed some extra fees apart from just the meeting fee, because only meeting fee has been given in the.
Yogesh, please, we should be clear. As on date, can you pay anything extra to AR?
As on date, there is nothing which can be paid extra.
Till the time amendment is, nothing can be paid. Now, second question is whether A and B present AR can be present in a COC meeting along with somebody else. That's the second question.
I mean, you want to see that whether AR can be accompanied by somebody else.
Yes.
No, he cannot. Because
Well,
he cannot.
To me, it should be the prerogative of the chairperson. At times,
Chairperson.
that's
Of the
important.
chair.
Because
normally you find hope buyers forming an association and they want one representative of their association be present along with AR in the meeting.
Yes.
But I tell you, I have handled 2 such disciplinary notices where the disciplinary notice has been issued, show cause notice has been issued to RP, that why have you invited even the association office bearers to COC meeting? There can be only AR, there cannot be any other second person. But that is, I think, too harsh, because in number of cases, what I have observed, that the resolution plans are coming from the associations.
Yes.
So unless you invite them, how can there be resolution of the insolvency of this corporate debtor? I think it's too harsh. It should be left to the discretion of the chairperson that who can be invited, who cannot be invited.
And if RP can apply his mind, allow him to apply his mind. Repetition there.
Okay. Next is representation in judicial proceedings. The observation is that there are instances where the IP failed to represent the CD in judicial proceedings. It means कोई भी case pending पड़ा हुआ है or any fresh case which can be filed against the CD, the IP must represent the CD in all those judicial proceedings. Whether you get a cost, whether cost is reimbursed or not, whether you have the money or not, if you can engage a lawyer, engage a lawyer. If you cannot engage a lawyer, be present there personally or send your authorized representative there. But CD should not be left unrepresented before the judicial authorities. This is what the crux of this observation is.
It's clear.
Related party transaction. Yes, Yogesh, you are saying something?
In the earlier slide, I said that there is no option left.
Yes. Related party transaction. There are instances where the IP failed to take approval of the COC before undertaking such transactions. So again, the advisory is do not enter into any related party transaction without taking the prior approval of the COC under section 28 subsection 1. Next observation is payment of to creditors during CIRP. While I was coming to office today, again I got this query from one of the leading lawyers in IBC that during this CIRP process, one of the financial creditors, rather the only financial creditor who is member of COC, he has been paid something during CIRP process out of the claim which has been filed. Can he be paid?
No.
Number one. Number two, there may be instances that where there are claims of a particular raw material supplier or a service provider, and you can buy this raw material only from that raw material supplier or the service provider. But he puts up a stipulation that if you want to buy material from me, you have to clear some of the earlier outstanding dues also.
Absolutely.
Now, to keep this company as a going concern, it's imperative on the part of the IP or RP to make some payment to him. Otherwise, this unit will close down.
But whether such payments can be made or not, if you make those payments, these become preferential payments, and it's not permissible.
And therefore, the observation is the IRP or RP cannot clear the dues of any creditor during the CIRP, as this amounts to giving preferential treatment to one creditor over others, and thereby alters the priority mandated under the code. I would like views of everybody here, all you four, but in very brief.
So GP, just to begin with, as your question regarding whether any payment, IRP, RP, no, but if personal guarantors wants to settle with the FC or make payment to FC, no restriction, I believe. One. Second issue which you pointed out, there are issues of post-dated checks, there are issues of letter of credit already being issued, and there are issues of guarantees which are provided. How to deal with those situations is a question mark which is always prevailing on the head of IRP, RP. In my view,
post-dated checks cannot be cleared later on. Post-dated cannot be cleared.
Yeah. But why you then the CD faces the director of CD faces question of 138 if EDC is you return that. Yes. Even if the balance is available, you are facing the action of 138 against the directors. How do you deal with that then? Yeah, that's the 2 points of the what about letter of credit, what are the guarantees, and what about these PDCs?
I have received an interesting. I have interesting answer. To keep going concern, it has to be paid subject to COC approval and monetize it.
Absolutely. That's what you have to do it.
I was supposed not COC approval as such, but I have done, it has a practical experience that you have to brought before the COC that this is the supplier, you need it. You have to bargain it out little bit amount, place it, explain the situation, everyone agree to run the business, it is required, then it is. Because one of the prime duty is to run the business of the company.
But I tell you, in one of the cases, with 100% consent of the COC, payment has been made to one of the creditors, one of the largest creditors. And IBBI issued show cause notice and asked and held him guilty and has asked him to deposit 34 lakhs of rupees with IBBI.
Yeah, so that
So
is
even
very clear.
with the approval of COC, you cannot make this payment as per IBBI.
Because the regulation is very clear that no payment can be made.
But Yogesh, I tell you, the objective of that RP was to keep the company as a going concern. And by making this payment, actually, he saved more than 3.5 crores of rupees for the CD. But he has been held guilty for this because law says you cannot make any payment.
And we just heard regulations are directory by somebody like. So anyway, I'll have 4 points. I'll have 4 points on this thing. First of all, it's very important to understand all the cases on the ground, they are different. Unless until a professional goes there, understands to run a business or a going concern, what exactly it means. It might have different connotations. So that is point one. Please allow the professional who you have reposed so much of trust to apply his mind. I keep repeating, I really love that statement that he needs to apply his mind. If he is applying, let him apply. Your point very valid. Unless until this mens rea, let's not kind of start with the trust deficit. There can be a question answer. Somebody sitting and reading the provisions and the rules and the regulations does not understand how a company is run and what is the requirement. The second last point is, if the case of a single FC, which you just gave an example of, or there still can be an option with 100% approval of all the creditors or something, that in spite of that, it actually may not amount to a preferential transaction. That is point one. What is preferential? Somebody else's money is being given to somebody else, right? On ground, it is possible that this was nobody's money. It is only being given to run the company. Nobody's prejudiced. And the final point is, which somebody also mentioned, I'm totally with them. Transparency and taking COC into confidence, recording it nicely is good enough. If you have a good answer, you didn't check, write a check in your own account or something, then we are good, because that was the need of the hour. So if you have noted it down, minutized, I think we are good. These situations will come, we'll have to figure it out. That's it.
I have received one observation. There are a number of observations actually on this issue also. One of the observation is here, RP received show cause notice from IBBI for making creditors payment of essential items during CIRP. On this, I think this is a question from Mr. TV Natarajan Subramaniam. My experience on this is that during CIRP period, you can make payment to essential services suppliers for the essential services you are utilizing during CIRP period. However, for earlier amounts before CIRP period, they cannot press, and you can always say, please file your claim, and no payment for the earlier period shall be made to them, all those essential service suppliers, and they have to supply it during CIRP period against payment. There is a landmark judgment of NCLAT in ANG Industries case. You can go through that judgment of 2017 judgment, where it has been, this issue has been absolutely clarified by the appellate authority. Now, next is on avoidance transactions. Here, this letter says that an RP is required to form an opinion on such transactions within 75 days of the ICD and to file applications to the adjudicating authority within 135 days of ICD. There are instances where the RP failed to independently apply mind to such transactions and file application in respect of them. In a few cases, he allowed himself to be directed by the COC or stakeholders. Actually, this is a very, very debatable subject. First of all, he has to form his opinion within 75 days. What will happen if this opinion is not formed within 75 days? Who should be communicated within 75 days that I have formed this opinion? Should it be placed before COC? And then within 135 days, you have to make an application to adjudicating authority. If IP is of the opinion that no such transaction has taken place, should he still form his opinion, and should he communicate this opinion to somebody? Because in many of the cases, I have seen that show cause notices actually forces the IP to file an application regarding these avoidance transactions. So what is your experience on this? 80.
I came to know that I only filed the first application under this preferential transaction and all that. So it was now this days of deciding and making opinion and filing the application is practically very difficult. In 75 days, when we don't have much information, in 75 days, we have to go through the accounts and form the opinion that whether there is a chances. We have to prime facie form the opinion. And then in 135 days, file the application. Practically, it becomes difficult.
What I would like to contribute into this is that in most of the cases, I'm not saying all cases, in most of the cases, it says you have to look into such transactions in the last 2 years. So practically, if you look into these cases, which is going under CIRP, in the last 2 years, you will hardly find anything in the accounts, even if you have got the accounts. First of all, the main issue is that you don't have the data. Second issue is that even if you have the data, you will hardly find anything in the last 2 years because the project has been, not going well. Financial stress has been going for years. NPA has become 2 years, 3 years, 4 years, 5 years back. In real estate cases, the delay have been more than 5 years, 6 years. So practically, if you look into the transactions, you will hardly find anything in the last 2 years as given in the code. So I think there is some problem with respect to this code also, that this, in fact, the period also in the code, that this, whether this period can be extended for a further period of beyond these 2 years or not. That is basically one of the main questions which everybody is having a problem.
No, but the law is clear. Why should you have any problem on this? Law says 2 years, you go by 2 years. You don't go beyond 2 years. For fraudulent transaction, you go beyond 2 years. But for other transaction, don't go beyond 2 years.
So for the purpose of forming an opinion, it is only 2 years. So if it is only 2 years, you are not going to get any malified transactions in the last 2 years because there is hardly any transaction in the last 2 years in most of the cases. So what is the point? Basically, what is the purpose of this section? This section purpose was to find out the...
You know, there are undervalued transactions, there are preferential transactions, there are extortionate transactions. If you read the language of the malified, we are adding to that. And then there are forced transaction, fraudulent transaction. And I think any preferential or undervalued transaction may be called as a fraudulent transaction also. And the moment it is called fraudulent transaction, you can go travel beyond 2 years also. And then on the basis of that, you can always form your opinion. One more question is coming. The number of participants have written that question. Should one wait for the forensic audit report before filing this application, or you have already appointed forensic auditor, time is running out, his report has not come, should we go ahead and file this application? What is your view? Ravi, what is your view on this?
Then I'm totally, as far as I read IBC, I don't find a provision which says that you can straight away go for a forensic audit at the outset. You are supposed to go for a transaction audit first, then take the report, and maybe with the approval of COC only you can go ahead and go for the forensic audit. So I have been very firm on my view that you can't have direct forensic audit. So that 75 days, 135 days, so forensic is not going to happen for sure.
Sanjeev, what
you rely on transaction auditor, and as Yogesh rightly pointed out, you really don't have 2 years data information which is really substantial to it. And even if you find that, I've been fighting a case for 9 months now where promoters have transferred 5.63 crore into their account, and what we get is a hearing date, nothing beyond that.
But let me tell you one more thing. If there are 50 transactions and you suppose you file an application for those 50 transactions, you have to make all those 50 entities as respondents.
Absolutely, absolutely.
And that is a Herculean task. Who is going to follow up this case for years together against those 50 parties?
And you don't have the name and address of all these 50 people.
Yes, Sanjeev, you're saying something.
Right. So first of all, bringing the concept of forensic audit into the PUFE slightly complicates the issue. Currently, what we have on record as part of regulations is the PUFE funda, where, I mean, yes, we did hear Yogesh saying that, we may or may not have the information. Let's assume that, if a company is getting into a stressful position, there is a likelihood of having some preferential, some extortionate in last couple of years, but stick to 2 years, which is given. That's number one. The problem starts where they say RP failed to independently apply mine. Now, all you have is 75 days. It's a team effort. COC has been handling or interacting with the CD and the people much more than what you have. You just stepped in. You're trying to understand the, the tricks of trade. And if there is a direction or if there is a support coming from COC, then I don't see a problem there. That's problem, one, what is being highlighted here. So because the team effort, it's a joint thing where somebody has to decide, but here the onus is on the RP himself. If you come out with a prima facie, you need not tell anyone. Nobody is expecting you to kind of go and tell IBBI or adjudicating authority. They would hear from you only within 135 days, where you will actually put it down and make a complaint for respective transaction. But the point which was just raised is equally important. A, we have not seen enough success in terms of the hit rate. So you file an application, what happens out of that? It actually loses the value of, the entire terror has gone down. It's actually diluted. The worst part is you are the applicant. You initiate this avoidance transaction application. There is a resolution plan. It says that resolution plan will happen, liquidation will happen, irrespective whatever comes out of it. It's written, which means that if this case is fought forever, then you continue to be a party to that. Now, these are dangerous things. So though we talking about what is written, I think we need to think through and see through where the problem actually lies. So maybe given a choice out of the people who are hearing us, they'll say, forever we'll be dragged. So what will happen to the resolution, liquidation? The company is dissolved, everything is fine. But there is a case going on after 5 years. Now, whether you have an AFA or not, you will be summoned and you will be there. Is it what somebody wants? So we need to kind of, any issue we bring it up, whether it's IBBI, MCA, or whatever we are trying to explain, we need to look at a holistic thing and we need to close the loop. So that's a deterrent for people to not even get into the territory. Making 50 respondents, right? That's one problem. And then fighting it out for the rest of your life. And who will pay and all, I mean, those in any case we have discussed a lot. So I'm not repeating all that. So it adds to the tension for a practitioner. That's the problem. That's my
There is interestingly one more situation where you have filed an application against the promoter under the avoidance, and being an MSME promoter, he is putting up the plan also. Now, whether that plan should be considered from that promoter pending this application?
Leave it to COC. Leave it to COC. You disclose all the facts to COC. Legally is not barred. Legally is not, but you place it before COC. Let COC decide. Let COC take the call. Everybody is saying the COC is having best of the commercial wisdom. Let COC decide it.
But being
another point,
professional, you are supposed to give your views on the plan. You are putting it before the COC. But as per the due diligence given by you, whether you are, saying that it is all okay as per the IBC regulations and code?
My dear, you are not supposed to give your recommendation. You disclose everything to COC. If these are the transactions, I have filed an application. Now a plan has come from the same promoter. So the plan is before you. Let COC take a call whether you want to approve that plan or not.
I think the question being asked is, would this plan be compliant as per section 30 subsection 2? Which
my
means
answer is yes. My answer is yes. My answer is yes, it is compliant.
Okay.
Because you are nobody to decide it whether they entered into these transactions or not. The matter is sub judice before the court. Let the court decide it. I can't hold them guilty. Who am I? I being an RBI, I can't. Okay. I filed I formed my opinion. I filed the file. That's all.
And if he becomes guilty later on,
let COC take a call. Let COC write in this approval that if you are held guilty later on, it can happen. This can happen. That can happen. Let there be contractual binding between both the parties. Yes, Deepthi.
Few days back, COC has approved one such plan in my case.
Here's the example. Okay. Yes, Deepthi.
Yeah, and again, why you are limiting? If I am getting some information and I have to file and I get delayed, I will file it. So far, it's a process. I tried. Apparently, I did not got it. But if later on I found it, I have to file it, right? You are limiting 135 days. That is another point I am looking. Another one question I am raising. I am not allowed, but with Madan, your permission, the question that whether this forensic audit report or transaction audit report should be shared with resolution applicant when the matter is pending with NCLT. That itself is also another.
No, I'm not of the view report should be shared.
No.
I'm not of the this is my personal opinion.
Same here,
Yeah,
Madan.
because
And
there is a
my second
decided
opinion, my
case
second opinion, Deepti, my second opinion, I'm extending your question, whether a draft forensic report should be discussed with the promoters.
Yes.
My answer is that it should be discussed.
But
Yes, it should
Because
be an opportunity because
But I agree with Deepti on this issue that the report should be shared with the RA also, because he must know that what are the irregularities which have been committed during the CIRP or before the CIRP process by the promoters. Why it
which
should not be?
is sub.
Are
Which
you
is
saying
sub
with all the
judice.
PRAs? All the PRAs you mean? It's
Yes.
actually dangerous. Well, I mean, I'm otherwise agreeing to it, but imagine there are 10 people who are serious or not serious, whether they'll put a plan or not, and you are actually sharing something which is actually, I mean, I would say confidential.
we can have
Do
two opinion
you
on
have
this.
some-
All things are confidential, what you will share.
Sorry?
Now, with the
All
permission,
things.
Deepti, I'm reading some of the comments. We need to give time to them also. In many cases, adjudicating authority is not taking any proper action and applications and the cases are pending for more than 2 years. So we have discussed it. A series of contentious issues are being discussed today. RP doing his job in good faith and in earnest. Sad, but this looks like a witch hunt. NCLT can be wrong and AT corrects it. Supreme Court corrects the AT, but RP cannot be wrong in interpretation. Okay. Let's ask these regulators to demonstrate in one case themselves. Law has also given 90 days time to file charge sheet to investigating agencies in how many cases it is complied with. Okay, good observation. Now, some of the participants are giving go to police, go to CBI, go to Enforcement Directorate, invoke CRPC, invoke data protection law, and all these suggestions are coming from the participants. Okay, RP's fees coming to fees. Okay, we need to ignore some of the comments also, but I would like to prepare a compendium of all these issues. And if I'm able to do that, I will share it with the participants also later on. Now, coming to the next one, we have come to O. We are left with how many minutes? 15 minutes. We can extend it by another 10-15 minutes. No problem. We have to cover till Z. Supply of information. It says section 29 of the code casts a duty on the RP to provide access to all relevant information to prospective RAs in physical and electronic form. It has been observed that RPs did not provide the relevant information to prospective RAs and members of the COC. So it means whatever you are expected to provide, what are supposed to provide, you please provide that. And whatever you are not supposed to provide, don't provide that. I think this is the crux of this observation.
What is relevant?
Anybody wants to?
The main issue, GP, in this case is that what is the information which can be provided and which information is not to be provided. That is not clear.
Relevant.
We just issue one case that whether this forensic audit report can be provided to RA or not.
No, of course it cannot be provided as of now. My question that it should have been provided. But my point is again that there is no classified list which says that this is the information which has to be given and this is the information which cannot be given.
You know, whatever is there in the IM, I think you provide each and every information in the IM and all the annexure there to have to be provided to PRAs. Deepti, you want to say something?
What
Deepti,
is
you want
not
to say something?
what is not to be given, even illustrative list will help.
I think we can all approach IBBI and prepare that particular list also, what is not to be given. I think there should be done some directions on that also, some advisory on that.
Our disciplinary action.
I think we all can prepare some document which can be called best practices. Let's do that. Let's provide that service to our fellow professionals.
Here, sorry, one thing. I also given one more suggestion to them that what is resolution applicant should take care. It should be guidance to them. They are going to lawyers, but they should be also given that.
Okay. Next is, sorry, just a minute. Yeah, confidential undertaking. There are instances where the RP shared the documents with the members of the COC and or the prospective resolution applicants without obtaining the required undertaking. Okay, the advisory is take the required non-disclosure undertaking and then share the information. We should take it as right. If we are not following it, we need to follow it. This saves our skin actually.
Next.
Disclosure of information. Yes, you are saying something, Yogesh?
No, nothing. Next.
Okay. Now here, one line I have highlighted in red color. The details of valuation are required to be disclosed to every member of the COC in electronic form on receipt of a confidentiality undertaking. To what extent this is true? It's saying the details of valuation. They are not saying valuation. They are saying details of valuation. Does it mean valuation report? Or what does it mean? Now IBBI is saying it, that the details of valuation are required to be disclosed to every member of COC. What according to you does it mean?
See, practically, if you see, if you have given the information as far as the valuation is concerned, that this is the fair market value and this is the liquidation value. That is the minimum information which need to be given. So if you give the entire report also, how does it make a difference?
Yeah, I'm just asking it. I'm not commenting. I'm just asking you.
So my view is that if you are at least you are required to provide the fair market value and the liquidation value. That is
valuation. That is valuation. That's okay. That's okay. But the details of valuation, does it include valuation report also?
I'm coming to that only. That once you are giving the valuations, then automatically it is derived out of the valuation reports, and there is no harm in giving the copies of the valuation reports to COC members.
Deepti, what do you say? Can you share the entire valuation report with the members of COC? You're on mute mode.
Yeah. Valuation report, as per the law, I know this is something wrong, details of valuation, because the law is clear that after resolution plan and when it is to be shared and all that. So again, then giving this kind of wording, details of valuation, we have to refer the law.
No, it has to be given at the time of considering the resolution plan only, not before that.
Okay, let's be brief. Ravi, what's your view? Whether valuation report should be shared or not with members of COC? Yes or no?
There is a clear provision when it has to be shared.
Pardon?
There is a provision when it has to be shared post the resolution plan is in place.
Where is the provision that valuation report is to be shared? Where is the provision?
After the resolution plan is in place.
Okay.
You cannot disclose the valuation prior to that.
Yes or no?
After resolution plan is received, you can share the valuation reports with the COC members against a confidentiality undertaking. And please do not read this like a law or a code, because this is just a facilitation letter. So details of valuation is nothing more than a valuation report. I don't find any
the
other
consensus is it can be shared with the members of COC on receipt of a resolution plan, not otherwise.
Yeah.
Is it right?
And against undertaking. Against undertaking.
Against undertaking.
Against undertaking, it's okay.
So if resolution plan is not received, you can't share. That is
correct.
Okay. That's the crux.
Yes.
So here the observation is, in a few cases, certain information meant for entitled stakeholders were disclosed in the public domain, and certain information meant for the public were not disclosed in public domain, or certain information were disclosed before or after the time specified in law. So what the advisory is, whatever is required to be disclosed, disclose. Whatever is not required to be disclosed, do not disclose. And whatever needs to be disclosed, there should be timely disclosure. This This is what the advisory is in this.
Next.
Okay,
So
great.
if resolution plan is not received, you have not to disclose valuation report.
Yes.
But while you are filing an application for liquidation, then you have to attach the liquidation reports.
Okay, now next question is pertaining again real estate. Windows for views, the 12 hours and 24 hours and all that. So I would like to ask this question to Yogesh only. It is observed that such timelines were not adhered to in few cases and voting window remained open for a period shorter than that is provided in the regulation or for unusually long periods. Do you have any comment? I think it's a advisory, good advisory.
See, it is saying at least 24 hours.
Right.
So we have to keep it open. That is number one. There is no
Okay.
option. We have to follow. If
Right.
you are giving number of hours, it is a violation. Second
Right.
is if giving it more because the numbers are so large. So it is always the purpose is to get the major
Participation.
wider participation from the allottees. So it is always better to keep the window open for this 24 hours, more than 24 hours, and voting also for not less than, it is the law says only 12 hours, but in case of real estate, we are keeping it open for 2 days or 3 days or 4 days, considering that what kind of voting is happening. So I think it is advisable to have the wider participation to open it for more than what is required minimum in the as per the code and regulations.
Okay. Next is circulation of minutes. Here it says there are instances where IRP or RP failed to record and circulate minutes promptly or did it late. This may reflect poorly on the competence and integrity of the IP and cause delay in critical decisions. Actually, the observation is on the minutes should be shared promptly
In
and
time.
within the timelines.
Time.
But I think on minutes, IBBI should come out with a detailed advisory for IPs. There are a number of practices which are going on in the market, whether
Absolutely.
final minutes should be shared or whether draft minutes should be shared, whether the minutes are subject to approval or ratification or confirmation, or whether these minutes should be taken note of at the next meeting, or IP can remain silent after circulation of the minutes. On these issues, there is no answer which has been provided in the code. And I think, according to, if you ask me, because I have with me and Deepti both have remained members of SSB also at ICSI, I think whatever the provisions for the minutes for the board meetings are concerned, I think all those provisions can be made applicable here. That is a perfect guidance for the insolvency professionals, that how the minutes are to prepared, noted, circulated, and preserved. I think we need to make a presentation to IBBI on this. Sanjeev ji, yes, your quick view on this.
A quick check as per your Companies Act, how much time do we get to kind of send the minutes?
7 days minutes.
7 days. So when something has to be done in 48 hours in hostile conditions, why do we add more procedural issues in this? IBC.
The Companies Act also provide whatever is the stricter provision that has to be complied with, that has to be followed. So if it is 48 hours here, 48 hours will overrule that 7 days.
Absolutely. So you've taken the time from here, but you've gone into a detailed process of creating minutes and circulations. So I think that'll be like, putting more pressure on the IPs. And I just read someone stating that we said within 48 hours, the draft minutes. There's no concept of a draft minutes. Why don't we have the meetings in a way that towards the end of the meeting, you really sum it up and send it there, for everyone to take a call. And maybe unless until something which has really kind of missed out, which is too grave or something, then I understand making a small change as an addendum or something. Otherwise, please, participants, try and avoid getting into this habit of a draft minute sent and then wait for people to revert. Otherwise, you're getting into a loop. Your 48 hours are never going to end. Nowhere in the code or regulations is written 48 hours for draft minute. That's the final.
If you circulate, because I'm against this concept of draft minutes in IBC, if you circulate a draft minute, you can never, when the minutes are to be finalized, nobody can decide that. Then you will keep on waiting, receiving the command and filing the command, then the decision will never be final. You will not be able to implement the decision.
So RP has to sign and send the minutes effectively.
Absolutely.
Is to finalize. In case something is left out, it can be commented upon by the COC members, which can be taken into consideration in the next minutes.
Next minute.
So, Amita Desai has written here the SS1 compliance to be avoided, but practical views to be taken. I 100% in agreement with her that yes, SS1 compliance is mutatis mutandis. Wherever it's possible, where it's feasible, where it's practical, please adopt it, otherwise leave it.
It need to be redrafted for this purpose.
Yes. Okay.
Next.
That is a Deepti, you remember when we were at SSB, we said that there should be someone standard for COC meetings also.
Yeah, pending agenda for both of us.
Yes, for both of us, yes. Okay, next is inclusion of cost in IRPC. It says that law does not allow inclusion of any other cost in IRPC. A member of COC may incur cost to travel to attend to the meeting of COC. The COC may incur cost to obtain a legal advice or in engaging a professional COC. The CD may have incurred a cost before the ICD, and the RP may pay a penalty for non-compliance with any law during CIRP date. All these indicative costs cannot be included in CIRP cost. This is what an advisory from IBBI. I'm in 100% agreement with this, except the last one, that a RP may pay a penalty for non-compliance with any of the law during CIRP. If this non-compliance beyond the control of RP and a penalty has been levied and CD has been asked to pay it, should it not become a part of CIRP cost? Should this RP pay this cost from his own pocket? My answer is no.
No.
It should be allowed to be made part of CIRP cost. I hope everybody will agree with me on this.
Yes, yes, good.
Thank you. Compliance with applicable laws. Here they have given an example of listed company. So listing regulations, LODR, SEBI laws. I go beyond that. Compliance with Companies Act, compliance with labor laws, compliance with tax laws. Now the observation is that there have been instances where an IRP or RP failed to comply with requirements of various laws. In my view, only endeavor should be made to comply with laws. He cannot ensure to comply with all the laws. अगर एक कंपनी इतनी लॉ कंप्लायंट होती तो कभी CIRP में ना जाती, एक कंपनी कभी डिफॉल्टर ही ना बनती, इंसॉल्वेंसी में नहीं जाती. अगर इंसॉल्वेंसी में गई है, certainly everything is haywire there in this company, and now you are expecting this IRP or RP that within a span of 180 days or 270 days वो कंपनी की इंसॉल्वेंसी भी रिजॉल्व कर ले और कंपनी की सारी कंप्लायंसेस भी कर ले, पिछली अगली सारी.
और वो पेनल्टी पे करे तो वो आरपी सीआरपी कॉस्ट में नहीं आएगा.
I think here they are asking too much. This should not be the IBBI should reconsider this particular mistake. This is not a mistake. According to me, this is beyond the control of the RP or RP. What are your views?
IBBI should give a magic wand to all the IPs to comply with all the laws.
Yes, Sanjeev, what do you say?
If only there is a list available somewhere that what are those all the laws which need to be complied with. I'm still waiting for.
Not available with the large listed companies also.
Absolutely the point.
Having a list which laws are applicable to a particular company.
So even when first time I read section 30 subsection 2b said should be complied with all the applicable laws. I started what all laws I need to understand, and everyone continues to always say with applicable laws. How easy is this word? Similar to reasonable. So the day we define reasonable, that very day we need to define all the applicable laws. Need to have a website, some list. So at least I can check box. And you are right. You said in your remark itself that a company which is under stress and today it's struggling and it's become an NP and it has come to CRP. Imagine what the company is going through. The employees have left. The CD is like, promoters are hostile. You are working against the tide. You have a compliance calendar, you have timelines, you have to ensure going concern, right? You have to do practically everything. Now, on top of it, you're saying that, any non-compliance. Now, what is this any non-compliance, right? So, I have always been vocal on saying that the compliances for a company under CRP should be reduced to half. Let there be a separate debate on this thing. They actually should be reduced to half. Make it very simple. Whatever is easy, I need to do, I'll be very happy to. And the moment you get into liquidation, they should be made zero. The very concept of liquidation order is signing the death warrant. What on earth are we talking about? कि ये नहीं हुआ, वो नहीं हुआ, audit नहीं करवाया, वो सब नहीं किया. अरे hello, I am supposed to strip the company of its asset and sell it. What are we talking? So these two suggestions I have always tried to make. As and when somebody wants to listen, I'm happy to be part of the debate, stating reduce by half if the company is in CRP, make it practical for people to adhere or comply, and then in liquidation make it zero. That's it.
Okay, one interesting observation has come: applicable laws must be subject to moratorium.
Absolutely. Frankly, I mean, that's what.
That's what precisely Sanjeev is saying, that you are effectively not required to comply with.
I think that I should be there. There's some circular or clarification or advisory that IP or RP or IRP should endeavor to comply with the applicable laws. Only endeavor should be there. Whatever within your domain, you should be able to, you can do it. If you can't do it, that will show your best effort. That's all. Show your bona fide there. That's all.
In this entire paragraph, I failed to see endeavor again getting repeated. So was there a reason this time not to use that? Or we should have said reasonable, try reasonable, apply your mind. I don't see endeavor written anywhere else.
No, I think
Next, last three, 4 points. Sorry. Timeline.
Yeah.
There are instances where IP failed to adhere to the specified timelines. I think in the entire law, all timelines are mandatory for IPs. For all others, the timelines are directory in nature.
IP is the main.
Huh?
IP is the main.
When you prepare the list, you have almost 65, 70 numbers, lines which run for timeline.
The way nobody is cooperating with IPs, whether it's a COC or the erstwhile directors, he's not getting orders on time from the adjudicating authority, and he's not getting cooperation from anybody. He's not getting money, and then you expect him to adhere to the timelines. I think you are asking the moon from the IP. That's not possible.
IP is made a code for all these timelines.
Sanjeev ji, please kuch carry kar lena isme se issues na, as it is for your next meeting with the IBBI.
Yeah, important is I would really look forward to that meeting because we'll have a representative from IBBI and it will be great to see his reactions and response. In this case, my only suggestion would be in timelines. To the best of our ability, we try and adhere to whatever. So in case there is any procedural or a technical slip or a slippage, I think there can be a dialogue and it can be understood what was the reason rather than getting into a disciplinary action or a show cause and all, because everything does not work the way we want. There's a lot of interdependency. 3 days, 10 days, 7 days, you have a Saturday, Sunday, Holi, Diwali. Nobody is like, everyone shuts, but our meter continues, right? In terms of, so I think people need to be reasonable. Till the time within 180, within 270, you can do something, we should be still okay with that. That's a suggestion.
Madan, the problem is that the form uploading, etc., is so computer driven that even if there is some delay by COC, some other reason, you have no other option but to upload it. At the moment there's a delay on part, as you said, COC is not cooperating, and there's a delay, and when you upload the form, you are responsible.
And charging, let's see, why again that you have mens rea, then carelessness. It's form filing, if even late filing, timeline and all that, even in form filing, even MCA government is allowing to corporate debtor and all that, okay, late filing fee and all that, at least, but here to every time, even 1 day delay, mens rea, your intention, collusion, why that always a suspicion, always, we are always subject to suspicion. This is not a correct approach.
Dipti, I think it's like selling your 10 years old car and the buyer says, no, their tires are not perfect. The paint is not there. It's not starting and the suspension is bad. I mean, he's for 1 lakh of rupees, he's asking for the value for 10 lakhs of rupees. The same thing is here. There's a sick company, it's insolvent company, has been in default, has been non-compliant with the majority of the legislation. And now you're expecting the IP to complete every damn thing within a span of 180 to 270 days because the law has prescribed the timelines and without any cooperation and coordination from anybody and without having any funds. Okay, next. Compliance with orders, there are a few instances where the RP failed to comply with directions of the adjudicating authority. I think advice is very clear. Whatever adjudicating authority says, you please follow that. Here I would like to share one particular case. Adjudicating authority asked the RP to conduct the valuation of the assets, third valuation. He brought this matter before COC. COC says, sorry, we don't have money. We can't give you any money for valuation. Valuation would have cost more than 5 lakhs of rupees. He submitted his report to adjudicating authority that I place your directions before COC. COC says, sorry, we will not provide you funds. So I could not get the valuation done. Adjudicating authority says, sorry, we don't buy this argument. We are recommending your name to IBBI for disciplinary action. Now tell me what can be done. How can you follow? How can you comply with the directions of adjudicating authority in such a case? You are not getting your remuneration and now you have to spend the money for valuation also from your own pocket. Is it fair?
So if you look at from that angle, all these points again leads to one point, that all there are directions to the IPs only. What about the directions to the COCs, to the courts, to the IBBI, to the other stakeholders?
I tell you, I give you the answer because IBBI is regulator for IPs and not for banks and COC members or the stakeholders.
No, but they have to give the directions.
But still they have issued a circular that they will come with the mandate.
Now
Just
if they have looked it from
but
that angle,
that's not being followed, that's a separate issue. But they have issued a circular.
recently they have issued a circular that all applicants who are filing the application should file with the IBBI also. So if they are, whether they are covered the applicants or not.
Okay. Last two issues. Maintenance of records. It has been observed in a few cases that IP failed to produce complete records in respect of CIRP conducted by him. I think an IP is expected to prepare to maintain all these records, and whenever asked to produce, he should be able to produce them before the inspecting authority or IPA or IBBI. And I think next issue is also same, that cooperation with the inspecting authority. So whenever there is inspection either by IPA or by IBBI, it is written here that there are instances where an IP failed to cooperate with the IA and did not produce documents and records promptly and prolonged inspection on some excuse or the other. One of the excuses during this pandemic period was that the corona is there, so certainly the office is closed or the staff is not coming or staff is met with corona disease and all that. But advisory is that you must maintain the records, and whenever there is inspection, please place these records before the inspecting authority, and there is nothing wrong in this. I hope all of you will agree with me on this.
Yes.
Okay, now I stop sharing this presentation and I will come to some of the observations and questions of the participants also. We'll take another 10-15 minutes minimum. Friends, be there with us. Okay. The two questions which I received day before yesterday, can this facilitation letter issued by IBBI be relied upon during NCLT hearing or during COC meetings? What do you say?
We have choice, but whether it will be accepted or not, we can rely upon, but let NCLT accept or reject.
So whatever suits you, rely upon that. And next is that even though the facilitation letter is in respect of CIRP, can we assume some of the points are extended to liquidation and voluntary liquidation also?
Yes.
Yeah.
My answer is yes, as far as this appointment of the professionals, disclosure and related party transaction is concerned, I think this can be extended to.
But one point which I want to make GP here is that in most of the times, IBBI is coming out with a regulation or circular only for CIRP. Why don't they issue the same thing for the liquidation as well at the same time? Why do they have to leave a gap between CIRP and liquidation?
Same happened, in case in the month of March also.
Yes.
The liquidation regulation, CIRP regulation, the exclusion of period.
That came after 3 weeks.
Yes.
Similarly, I guess
Ishan, now you can pitch in. Ishan, you can enter now, and if you can raise some of the questions which have been shared by the participants.
is
If you want to ask
32A
this
also
question,
clear?
3, 4
I
questions.
have this query 32A, which came as a, and as an amendment, primarily because of Bhushan Power Steel. Was it, made applicable for liquidation also, for a sale of a going concern in liquidation? I think that's equally important because practically there's no difference. Of course, we have a different debate as to what exactly is going concern that is being challenged, but 32A needs to be applicable for selling of a going concern in liquidation as per regulation 32E or whatever it is, till the time they are not totally scrapped, because the bench has come out with saying that it's an ultra virus thing, which again is taking a U-turn, frankly. But anyway, I think we are more or less done. So over to you, Ishan.
No, not more or less done. No. Please wait, please wait. We have a lot to be discussed. Number of issues are there. Ishan, you can raise 3, 4 questions which are actually pertaining to today's discussion paper only. Because some of the questions are beyond that. We would not like to take those questions.
I think you guys have covered major ground. I think this can be a trend setter for discussion on issues and how they can be dealt with, or at least, this can be a voice of concern that can be communicated to the concerned authorities, because a lot has been discussed, a lot of comments, a lot of questions, which just show the kinds of issues that IPs are facing. And I think more or less a lot has been addressed. So there's not much that I can cherry pick, except that I can ask the panelists to in fact open the Q&A tab. And if you see there is some question that relates to a practical experience or a theoretical aspect that you consider is something that you can deal with, I think that would be a better ideal scenario. Mr. Ahuja, Mr. Gupta, Mr. Kapoor, if you can just, open the Q&A tab on your system, you'll see the questions that have been raised. If something that you feel, part of which has not been covered, but where you think you can add more value to what the participants are seeking, then I think it would be great.
Why one of the pertinent question is the if the COC doesn't approve the expenses of the professionals at all, then who will pay them? I think this we discussed during the course also. The IBBI should come out with an advisory on this also, and law should be clear on this, that you don't give authority to IP for appointment only, but give him authority to decide the remuneration and pay the remuneration also. I think the law needs amendment on this. Otherwise, this will continue like this. Only stalemate will continue. I think majority of the questions we have already answered, or some of the questions do not have answer at all.
Now, the other challenge is that I'm facing the heat. What exactly I'm supposed to do on 28th? In terms of how aggressive one can go directly, because here we IPs practitioners are discussing between us. Our tone, our experience, our language can be different. But once you sit with a representative from there, then one has to be really choosy, about the language, about this entire process of seeking response, I would say. But let's see, because a lot of queries, as we said, that if some of the queries do not have an answer, that is primarily because there has to be a tweak which is required, whether it's code or whether it's a regulation or whether it's advisory, whether it has to do something with the COC or other stakeholders. To that extent, I think we have a challenge, and it is being clearly brought out. So, are these mistakes or these are common mistakes? I think we've had enough of it. So, as far as I am concerned, I think I've gone through the Q&A thing, and more or less, Ishan, we've covered practically all of it. So,
Ishan, I would like to ask one question which is there in the chat box. And I want to ask this question to you. What is your view on this? Can NCLT be given amicus curiae?
Well, that's a googly.
Yes,
because because it'll become a question of locus and who this person is and how that can be concerned with the proceedings.
But Ishan, we have witnessed in principal bench. Principal bench actually appointed one of the senior lawyers sitting in the courtroom as amicus curiae in a couple of cases that we have observed.
Good thing is because that's happened. That can happen. But in a practical scenario, can't pin too much hopes on other coordinate benches, because I think problem lies there. At the end of the day, you still have one presiding bench which sits in Delhi, and of course through the orders there is people are paying heed and giving deference to what the principal bench is doing. But in a practical scenario, it's still going to take some time to adapt to those practices. And like, in one of the questions, Ajinkya pointed out that what's happening in Mumbai, the bench still looks at what IRPs and RPs are doing, that, they're not doing enough at the end of the day. So yes, the path is still uphill. The battle is still a big one. And it's like, literally, as they say, aag ka dariya doob ke jana hai. It's a lot like that for the insolvency professionals.
So you can imagine somebody sitting in US, he can feel the heat of Aka Darya, and the rest of 200 guys who were there. You can imagine the heat we are going through. But just a connected question: this amicus curiae thing, is it a discretion of the bench, or you're saying it can actually happen as a best practice, which then eventually gets followed by the others? How
I
does
mean,
it
at
work?
the end of the day, amicus just means friend of court,
Yeah.
someone who's there to assist the court, and he
Agree.
definitely someone who does not have an interest in the outcome of that case,
Okay,
or
but I
concerned
always
with
thought.
helping the court.
Okay, I always thought I was taken as officer of the court and I was supposed to assist the court even as a IP. But
It,
suddenly I figured out that they do not have adequate trust in me now.
But I tell you, yesterday in one of the cases, particular bench was asking one particular lawyer, Mr. So and so, you need to assist me. You need to assist me.
Yeah. Okay.
Yeah, that's
Actually,
that's what they say. Even to RP
It is
also they make the
happening.
same judgment. Yeah. But when it comes to delivering order, why you're not present? Why we should not be penalized?
it's like, in a sense, that's the entire purpose. In a sense, everyone having the authority to represent someone in the court is an officer on the court. Inherently, we all have that duty to assist the court in something whenever called upon, and the court can do that. It happens so many times. The higher the court is, the more that happens with the regular faces that keep appearing in them. But it can't be a blanket or straitjacket formula that you can expect can work. You say out of turn, and these days I hear that even the court master in NCLT just admonishes people for not being in line or trying to toe the line. So
That is true.
now, before I ask Ishan to give his concluding remarks along with the poll result also, I'll request each of the panelists to give their comments on the event in not more than 10 seconds each. Lokesh.
What? What is your question?
There's no question.
His seconds are over.
On this program or what?
About this program, yeah.
Excellent.
Okay. Sanjeev.
It should say everything.
Ravi.
I will not take 10 seconds.
Okay, Deepti, your turn.
We should have series of this.
Okay, great. So Ishan, over to you. My thanks to all the panelists. Ishan, over to you. And you need to come out with a poll result also.
yeah, I'm sharing the poll results. I didn't do too many polls because I think the conversation, the entire dialogue was moving so swiftly and so organically that this might have just, derailed concentration from the discussion. The discussion was fantastic, and I think a lot of IPs would have gained a lot in terms of their understanding. And as we could see from many of the comments and the comments raised in the Q&A tab, that there were a lot of issues that they could understand in a more practical scenario. I'm sure, given what they've experienced, given the knowledge that is available from others' experiences, and given what IBBI has said, I think it will also help a lot of the attendees today to not fall into the on the wrong side of IBBI's interpretation of things. So I think it was a great productive session. And as Mr. Satish Chugh is saying, our understanding increased a lot. I think a lot of value has been created for a lot of stakeholders who are actually concerned with this webinar in terms of the attendance and all. So a big congratulations to all the speakers, and a big congratulations to the attendees, because I'm sure this made a lot of sense to a lot of people. So hats off to all of you. Hats off for the wonderful insight that everyone brought to the table and brought to the screen. And I think that's amazing. I'll just quickly share the poll result of the other one also, because this concerns the entire premise of whether or not one should take up the assignment. And that is how to deal with the fee issue. Should a minimum fee be fixed? And 50%, about 63 people who answered this question said that there should be a minimum fee, and 1/3 of the attendees feel that let IB draw a fee first and then have it adjusted later, at least to cover for expenses, just to foot the bills. Two notorious people do feel that they should be at the mercy of COC or adjudicating authority. And 15% feel that yes, there should be something else. So long story short, I think it's not majority view, but at least half of them feel that yes, there should be a fixed minimum fee. And I think once this recording is up, a lot of IPs can re-review the discussion and perhaps share their views also wherever possible, wherever applicable, in whichever fora. And I think as we discussed in a previous event, when just as MM Kumar was there and Dr. UK Chaudhary was there, that it's still evolving, and with the efforts and with the contributions of everyone involved, even up to the Supreme Court, this piece of legislation, which someone said that the business community looks at as a big failure, will turn out to be something of great success and great value for everyone. So thank you, everyone, and let's.
Before I conclude, thanks Ishan and GP for the coordination. Thank you.
Thanks.
Let's do a nice screenshot, a happy screenshot before we sign off. I think that's very important.
With your smiling faces.
With the smiling faces.
This gets framed, right? This gets framed eventually.
This gets framed without anyone getting framed.
Chaliye, great. So nice.
Okay.
Thanks for the effort on
Thank
that.
you, everybody.
Thank you.
Thank you.
Thank you, Stay
Thank
safe.
you, your friends.
Stay healthy. Take
Thank
care,
you.
please. Thank you.